Justiciability refers to the types of matters that a court can adjudicate. This toolbox project observed common features across 17 jurisdictions, some of which allow parties to climate litigation successfully to promote regulation or change in the conduct of cooperation, while others hinder such achievement. Let me start with the cases where justiciability does not prevent successful climate litigation. This is seen in Canada, Nigeria, China, and India. The toolbox indicate 4 legal structures. 1. Highlighting the government's failure to adhere to its specific legal obligations rather than vague or broad misconduct. 2. Invoking specific statutory or constitutional provision that grant clear actionable rights. 3. Based on well-defined procedural grounds that clearly outline how courts can proceed with such cases. 4. Emphasizing the judiciary's role in delivering environmental or climate justice. It can be said that all of them remain the safe domain of genuine legal interpretation. However, we need to be aware that climate crisis has more and more recognized as a human rights issue or issue of justice, both of which are with no doubt at the center of the judicial domain. Now, let me move on to the cases where justiciability hinders the success of climate litigation. The project observed this phenomenon in the rest of countries in various shapes, which could be categorized into 2 groups. The first group relates to legal rules or material issues. This group consists of the separation of powers and political question doctrine and deference to administrative discretion. The second group relates to the procedural law, consists of displacement by written law, ripeness and actual controversy, enforceability and redressability. The aforementioned analysis finally drew some implications for future challenges and how we can come over these hurdles. Regarding the legal rules that related to the strict and political, there is room for reconsideration as to which of these 3 authorities should be mainly in charge of climate change issues. We have reached a point where it is no longer a policy issue, but a human rights issue. In addition, given the current situation in which the severe adverse effects of climate change are manifesting themselves in an unreasonable skewed way among those more vulnerable to climate change impact, this is no longer a problem of the majority, but of a few. And from this point, it becomes a matter of justice. From this 2 point of view, we can point out that the issue of climate change is without doubt a matter that should be handled by the justice sector. Regarding the procedural issues, first, the displacement by written rule should avoid the fact that the court cannot hear the case because of displacement, which may hinder the progress of global climate change measures. Next, the point of ripeness and actual controversy needs to consider the trade-off between the speed required for the climate change action. One approach that may be taken here is sort out the relationship with the precautionary principle. Finally, enforceability and redressability requires mutual understanding between administrative agencies and judicial agencies. The administrative agencies need to properly respect judicial decisions and follow their instructions. Also, the judiciary in turn is also required to issue judgment in a manner that facilitates the implementation of legal remedies by the administration. This is all from my part. Thank you very much for your attention.